Strauder versus West Virginia. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Strauder versus West Virginia, an opinion of the United States Supreme Court. Decided in the October term, 1879. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or Justice Field's dissent. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Strong delivered the opinion of the court. The plaintiff in error, a colored man, was indicated for murder in the Circuit Court of Ohio County in West Virginia on the 20th of October, 1874, and upon trial was convicted and sentenced. The record was then removed to the Supreme Court of the state, and there the judgment of the Circuit Court was affirmed. The present case is a writ of error to that court, and it is now, in substance, averred that at the trial in the state court, the defendant, now plaintiff in error, was denied rights to which he was entitled under the Constitution and laws of the United States. In the Circuit Court of the state, before the trial of the indictment was commenced, the defendant presented his petition, verified by his oath, praying for a removal of the cause into the Circuit Court of the United States, assigning as ground for the removal that, by virtue of the laws of the state of West Virginia, no colored man was eligible to be a member of the grand jury or to serve on the petty jury in the state, that white men are so eligible, and that by reason of his being a colored man and having been a slave, he had reason to believe, and did believe, he could not have the full and equal benefit of all laws and proceedings in the state of West Virginia for the security of his person as is enjoyed by white citizens, and that he had less chance of enforcing in the courts of the state his rights on the prosecution as a citizen of the United States, and that the probabilities of a denial of them to him as such citizen on every trial which might take place on the indictment in the courts of the state were much more enhanced than if he was a white man. This petition was denied by the state court, and the cause was forced to trial. Motions to quash the venire, because the law under which it was issued was unconstitutional, null, and void, and successive motions to challenge the array of the panel for a new trial and an arrest of judgment were then made, all of which were overruled and made by exceptions parts of the record. The law of the state to which reference was made in the petition for removal and in the several motions was enacted on the 12th of March, 1873, and it is as follows. All white male persons who are 21 years of age and who are citizens of this state shall be liable to serve as jurors, except as herein provided. The persons excepted are state officials. In this court, several errors have been assigned, and the controlling questions underlying them all are, first, whether, by the Constitution and laws of the United States, every citizen of the United States has a right to a trial of an indictment against him by a jury selected and impaneled without discrimination against his race or color because of race or color, and second, if he has such a right and is denied its enjoyment by the state in which he is indicted, may he cause the case to be removed into the Circuit Court of the United States. It is to be observed that the first of these questions is not whether a colored man, when an indictment has been preferred against him, has a right to a grand or petty jury composed in whole or in part of persons of his own race or color, but it is whether in the composition or selection of jurors by whom he is to be indicted or tried, all persons of his race or color may be excluded by law solely because of their race or color, so that by no possibility can any colored man sit upon the jury. The questions are important, for they demand a construction of the recent amendments of the Constitution. If the defendant has a right to have a jury selected for the trial of his case without discrimination against all persons of his race or color, because of their race or color. The right, if not created, is protected by those amendments and the legislation of Congress under them. The 14th Amendment ordains that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This is one of a series of constitutional provisions having a common purpose, namely securing to a race recently emancipated, a race that through many generations had been held in slavery, all the civil rights that the superior race enjoy. The true spirit and meaning of the amendments, as we said in the slaughterhouse cases, cannot be understood without keeping in view the history of the times when they were adopted and the general objects they plainly sought to accomplish. At the time when they were incorporated into the Constitution, it required little knowledge of human nature to anticipate that those who had long been regarded as an inferior and subject race would, when suddenly raised to the rank of citizenship, be looked upon with jealousy and positive dislike, and that state laws might be enacted or enforced to perpetuate the distinctions that had before existed. Discriminations against them had been habitual. It was well known that in some states laws making such discriminations then existed, and others might well be expected. The colored race, as a race, was abject and ignorant, and in that condition was unfitted to command the respect of those who had superior intelligence. Their training had left them mere children, and as such they needed the protection which a wise government extends to those who are unable to protect themselves. They especially needed protection against unfriendly action in the states where they were resident. It was in view of these considerations the 14th Amendment was framed and adopted. It was designed to assure to the colored race the enjoyment of all the civil rights that under the law are enjoyed by white persons, and to give to that race the protection of the general government in that enjoyment, whenever it should be denied by the states. It not only gave citizenship and the privileges of citizenship to persons of color, but it denied to any state the power to withhold from them the equal protection of the laws, and authorized Congress to enforce its provisions by appropriate legislation. To quote the language used by us in the slaughterhouse cases, no one can fail to be impressed with the one pervading purpose found in all the amendments, lying at the foundation of each, and without which none of them would have been suggested. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made free man and citizen from the oppressions of those who had formerly exercised unlimited dominion over them. So again, the existence of laws in the states where the newly emancipated Negroes resided, which discriminated with gross injustice and hardship against them as a class, was the evil to be remedied, and by it, the 14th Amendment, such laws were forbidden. If, however, the states did not conform their laws to its requirements, then, by the 5th section of the Article of Amendment, Congress was authorized to enforce it by suitable legislation. And it was added, we doubt very much whether any action of a state not directed by way of discrimination against the Negroes as a class will ever be held to come within the purview of this provision. If this is the spirit and meaning of the amendment, whether it means more or not, it is to be construed liberally, to carry out the purposes of its framers. It ordains that no state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, evidently referring to the newly made citizens, who, being citizens of the United States, are declared to be also citizens of the state in which they reside. It ordains that no state shall deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the laws. What is this but declaring that the law in the states shall be the same for the black as for the white, that all persons, whether